Thank you, Professor Tushnet, and so nice to see so many of you. And I'm glad that you have your food. Having food at lunchtime is extraordinarily important. I should say that I was asked to speak for about 30 to 40 minutes, which I plan to use that time. If any of you need to go, I won't mind if you do so. Now, Justice Holmes famously said, "The life of the law has not been logic, it's been experience." In this talk, I'll discuss the idea of experience, or in my meaning, events external to legal doctrine affecting the law. And yet I'm not going to talk about judicial decision-making very much. My focus instead is the power of social movements to shape and to be shaped by the law, and thus to influence social change. Now, what do I mean by social movements? I mean groups of citizens who are mobilized in support of a cause. Citizens, non-jurists, non-lawyers, who mobilize around any social cause. It could be liberal or conservative, for or against reproductive rights, for or against same-sex marriage, and the like. Now, all of these efforts connect to law because in our highly regulated society, all causes, all things pretty much connect to law. The theme that I'll advance during this talk is that social movements attempt to effect change, and thus the law, by deploying rights talk to frame disputes and to move their agendas forward, both with promise and with peril. To illustrate this theme, I'll refer to signature events in social and legal history. Before I dive in to that part of the talk, first I want to pause to consider what I mean by law. When I refer to law, I mean to invoke a thick understanding of law. So it's not only the Constitution that we're talking about, the paramount law, to quote Chief Justice John Marshall. There are other iterations of law that social movements invoke. So not just the Constitution, but movements supplement the Constitution and the legal corpus with other texts that tend to be more aspirational in terms of their language. The Declaration of Independence and the preamble to the Constitution, for example. They cite Supreme Court decisions, often loosely interpreted, norms derived from local custom, and popular understandings of what the law should be to advance their causes. In other words, law is a much broader and a more supple concept than doctrine that we teach and learn about in law school in the hands of social movements. Finally, before diving into these examples of social movements interacting with law, I want to do a bit of road mapping about how movements use the law. 4 major ways I'm talking about. First, to make legal claims. Second, for moral suasion. Third, for cultural identification and critique. And finally, for political mobilization, which is to say, in the hands of social movements, law is deployed strategically and opportunistically. Now, having established that conceptual framework, let's consider some of these episodes in social and legal history to make the point. Now, one of the ways in which social movement actors can deploy the law is pretty conventional. It's what we're accustomed to. They can use the law to make claims in court. In the textbook example, the movement has a grievance, and it turns to a lawyer to translate that grievance into the language of law, into a legal or constitutional claim. In this manner, the lawyer is a translator for the social cause. The campaign to end Jim Crow in schools is a model of this type of use of the law. The campaign was led by the NAACP Legal Defense Fund, headed by Thurgood Marshall, who went on to become a U.S. Supreme Court Justice, who really jealously guarded the making of legal claims as the approach to social change. Marshall insisted that the way to change America was through the courts. In the face of criticism by intellectuals and activists who thought that, well, common law is a strange tool for social change in the context of race. Why did they think it was strange? Well, because the Constitution had been invoked to justify slavery, to justify segregation, because of precedents such as Plessy versus Ferguson, upholding segregation on rail cars, appeared to be a daunting obstacle to a court-based path to equality. So many people thought that Marshall was naive, although Marshall, in fact, had a critical consciousness about the law. And yet, still today, I want to emphasize, commentators, some of them, think that the legal system is a strange arena to mediate the claims of social movements. Skeptics worry that lawyers and judges, in the process of mediating those claims, will misinterpret them, will water them down, or simply reject the legitimate claims of people who are operating outside of the legal profession. Now, the point that I want to make, the main point, is that in reality, Marshall and the Legal Defense Fund did not fight their battle alone, even as he and other lawyers litigated claims in court. There were many external factors that created a favorable environment for the legal arguments. There was World War II, a war against fascism that exposed the hypocrisy of American democracy premised on segregation. There were black soldiers who were frustrated by being mistreated who came back stateside and took stands against segregation. There were lynchings that dramatized the depravity of white supremacy, increased black voting power in the North. In other words, it is impossible to neatly divide the world of litigation from the many other ways in which social movements can have an impact and try to utilize the law. So all of these things form the context in which Thurgood Marshall litigated and the Supreme Court decided Brown versus Board of Education, the case that, in fact, overruled Plessy versus Ferguson in schools. Conversations in chambers between and among the Supreme Court justices show that context mattered, as Professor Klarman has written. So Hugo Black had the war on his mind. He calls segregation Hitler's creed. Justice Robert Jackson concluded that upholding Plessy was untenable in light of how far blacks had come already under segregation, saying, "Black progress under segregation has been spectacular. His rise was one of the swiftest and most dramatic in the annals of history." Thus, really the court couldn't countenance. It would be an embarrassment to affirm the principle of inferiority that was at the bottom of the segregation statutes. So it turns out that Brown, often called the most important constitutional case of the 20th century, has more to do with context and politics, perhaps, than it has to do with law. Now, if you're a legal formalist, that outcome might be unsettling. However, from a social movement perspective, it's very useful to observe how global matters, how the work of the people themselves can have an impact on law on the books. Now, let's push further. Let's drill down on the contributions of the direct action wing of the Black freedom struggle to the statutory changes of the Civil Rights era. Now, that wing included two different groups. A group of reformers led by Dr. King, and a group of students who were more ideologically radical than the reformers, led by the Student Nonviolent Coordinating Committee called SNCC. Now, both groups of direct action workers are different from Marshall in that they're activists and not lawyers, and yet the further point to be made is that the two groups are demographically and ideologically different from each other. And they deploy the law in different ways. I underscore this point because these differences occur all the time in social movements. You know, whether it's religious and economic conservatives trying to hold it all together, or the reformist versus more radical opponents of police brutality. This difference within sameness can be a benefit and a detriment to social movements. Now, turning back to King, who was the leader agent of the movement, known for nonviolent campaigns against segregation in Montgomery, Birmingham, Selma. King deployed the law for moral suasion, a use that allows the layperson a great deal of interpretive space. King frequently called on constitutional concepts such as liberty, equality, citizenship. He referred to the rule of law. He invoked the words of the Declaration of Independence, of Brown versus Board of Education, to argue that race discrimination not only violated the laws of man, but the laws of God. He put it all together. So those who opposed the movement opposed our highest ideals and opposed God, which is not really a good place to find oneself, right? So King articulated these views during the Montgomery bus boycott, where he told a group of protesters that the rights belonging to citizens in a constitutional democracy justify the boycott. He said, "We are here because first and foremost, we are American citizens, and we are determined to apply our citizenship to the fullness of its means. We are here also because our love for democracy, because of our deep-seated belief that democracy transformed from thin paper to thick action is the greatest form of government on earth." And I want to commend Professor Kennedy's article to you precisely on this point about the Montgomery bus boycott. So he not only talked about democracy, he talked about Brown, which was decided a year before the boycott. He says, "If we are wrong, the Supreme Court of this nation is wrong. If we are wrong, the Constitution of the United States is wrong. If we are wrong, God Almighty is wrong." And so he's reasoning at a very high level of generality. One violation of the Constitution he's suggesting begets another, and besides, God approves of Brown. Now, it's not so usually straightforward in a classroom, and yet you have to appreciate that his audience, which longs for inspiration, which is religious. He's in a church, the Holt Street Baptist Church, which is patriotic. It works. It's inspirational language, and it puts opponents of the campaign on the defensive. What about the March on Washington, where King made similar analytical moves? This is in August of 1963, where he juxtaposed the words of the Emancipation Proclamation to those of the Declaration of Independence and the Constitution to powerful effect. Despite the proclamation, he noted, Black Americans still had not achieved freedom, the freedom promised in the thin paper of the Declaration. We hold these truths self-evident that all men are created equal. 100 years later, King said, the life of the Negro is still sadly crippled by the manacles of segregation and the chains of discrimination. Therefore, blacks had come to the Capitol seeking redress, seeking to redeem a promissory note. More legal terminology. He's talking commercial paper, folks. And it works. He's articulating a vision of equality that's deeply rooted in the American dream, coupling the sermons. It's not only sermons, of course, it's with protests in the face of violent resistance. And it's in this way that King is so important to laying the groundwork for the enactment of the Omnibus Anti-Discrimination Law, the Civil Rights Act of 1964, and the next year, the Voting Rights Act of 1965. Now, let's consider SNCC. Like Marshall and King, SNCC deployed rights talk. However, SNCC speaks in a different voice. If Marshall made legal claims and King evoked the law for moral suasion, SNCC invoked the nation's founding documents and court cases to engage in cultural critique and to politically mobilize people on the ground. If King and Marshall hoped to achieve reform by currying favor with the nation-state, SNCC hoped to be a countervailing force to elite domination, and if necessary, to achieve freedom outside of prevailing governmental structures. So SNCC alluded to what Edwin Corrin called the cult of the Constitution to expose the hypocrisy of American institutions and to push forward an expansive agenda. Yes, desegregation, but desegregation was a necessary but insufficient precondition to freedom. The students demanded economic justice, affordable housing, community schools. They fought police brutality, colonialism. They talked about political and cultural empowerment for communities of color. In other words, theirs was a sweeping human rights agenda that really challenged America, including some of their friends, liberal reformers. Now, a major point to note about SNCC's relationship to law is that the Supreme Court played a prominent role in its articulation of grievance and its attempt to mobilize the public. Striking a contrast to Dr. King, who had praised Brown, SNCC argued that the court's actions in the aftermath of Brown illustrated that American institutions had failed African Americans. So they focused on how, in their interpretation, the court turned its back on its own decision in Brown 2, the 1955 remedial order. So listen to the words of John Lewis, who was a founder and chairman of SNCC, and now, of course, a congressman, explaining that after Brown, we thought we would be going to better schools, and it just didn't happen. Nothing changed. So SNCC cited disillusionment with the courts and with lawyers to justify more participatory tactics and this more expansive agenda that I mentioned. The students favored sit-ins, a series of sit-down protests at restaurants, theaters, and other places where blacks face discrimination. They also incorporated boycotts, pickets, community organizing, and strikes into their protest strategies. Now, the question is, why? What did SNCC believe the sit-ins and these other forms of protest added that the court-based activism lacked? And the answer is unmediated political struggle, unmediated by formalities, by rules, by doctrine, by judges in robes. Again, John Lewis explained it best. We were all about a mass movement, an irresistible movement of the masses, not a handful of lawyers in a closed courtroom, but hundreds, thousands of everyday people taking their cause and belief to the streets. And yet, the point that I make, one of the points that I make in the book that Professor Tushnet mentioned, is that it's hardly the case that the students gave up on the law. They continue to make legal claims, to invoke legal rhetoric, just mostly outside of the court for their own purposes and without a core belief in the efficacy of law. So the students argued that the foundational legal text that I've cited, that King cited, that Marshall cited, made promises that were not real but fictive. You might say that the students were proponents of the idea that rights are illusory. You might say that they believed that the myth of rights, to quote Professor Stuart Sheingold, facilitated oppression. So it's the belief in the power of law that facilitates oppression. So it's ironic, perhaps, that like the court-based activism of Marshall, like the moral suasion of Dr. King, the student movement actually helped to lay the groundwork for the Civil Rights Act and the Voting Rights Act of 1965. These are laws that prevented discrimination of all kinds, not just for Black Americans, but on a variety of bases, showing the wide benefits of social movement activism, as well as undermining at least some of the critique that SNCC made of the law. Now, the Black freedom struggle is just one of many movements that deploy the law as a resource. You might say that the 20th century freedom struggle continued a long resistance that reaches back to abolitionism and to woman suffrage. And I want to briefly mention both of those. Now, if Plessy versus Ferguson framed 20th century disputes over racial equality, it's Dred Scott that stirred consciousness in the 19th century. Dred Scott is the case where the court held that no person of African descent could be a citizen of the United States. It is a case that inspired fervent abolitionist resistance. The activists critiqued Dred Scott along with the fugitive slave law to attack slavery. They made arguments for moral suasion, for political mobilization, and legal claims. Consider the 1860 speech by Frederick Douglass, arguing that the Constitution did not, in fact, support slavery. He reached this conclusion through an ingenious textual interpretation of the Constitution. It rested in part on the preamble to the Constitution, which he read in a way that advanced his moral and political purposes. He said, the Constitution's language is we the people, not we the white people. Therefore, he denied that the Constitution guarantees the right to hold property in man. And I really, really commend that speech to you. William Lloyd Garrison, publisher of The Liberator and leader of the anti-slavery forces in Massachusetts, shared Douglass's outrage against slavery, but not his constitutional interpretation. Douglass is to M.L. King as Garrison is to SNCC. Garrison called the Constitution a bloody and wicked compact. In an 1854 address on the 4th of July, where he stood on a stage with an inverted American flag, Garrison actually lit a match to the Constitution, as well as to the fugitive slave law. It is a dramatic display of contempt for the Constitution, one that reflected the times, reflected the outrage of the abolitionists, and presaged the Civil War and Reconstruction to come. Now, moving forward, let's talk about women's suffrage, where we find that leaders of the National Women's Suffrage Association, Susan B. Anthony and Elizabeth Cady Stanton, organized a multifaceted strategy to get women to vote. The tactics included litigation, lobbying, and civil disobedience. Perhaps most famously, Anthony's illegal vote for president in 1872, followed by her giving an address where, like Frederick Douglass, she cited the preamble to the Constitution to justify her action, saying, the Constitution says we the people, not we the white male citizens, nor yet we the male citizens, but we the whole people who form the Union. Therefore, she argued that originally citizenship did not exclude women. Now, despite the elegance of Anthony's speech, women, in fact, only gain suffrage after the face of the Constitution itself changed in 1919 with the 19th Amendment to the Constitution. And yet, suffrages had laid the groundwork for that change. And I want to push forward to talk about the 20th century and women's activism when proponents of women's liberation attacked the sex discrimination that existed despite the 19th Amendment. I'm talking about the National Organization for Women, which took the lead with people like Betty Friedan, a co-founder, tethering the women's liberation movement to the Declaration of Independence, borrowing from Susan B. Anthony, borrowing from the civil rights struggle. In court, lawyers drew analogies to race discrimination, which was now constitutionally and statutorily prescribed. So, in the words of legal historian Serena Maire, the women reasoned from race with great success over time. And yet there was a problem. Some women's advocates criticized the reliance on the courts to do what was really the cultural work of ending male domination. The 14th Amendment demanded that women conform to the male norm, they argued, and that was far short of liberation. The types of arguments, the types of activism needed to destroy male supremacy were much more than a constitutional suit could offer, just the same as Snick argued that much more than the law was needed to disestablish white supremacy. So, sounding like Snick, the critics demanded critiques of the economic structure. They demanded cultural change, and they did something about it. They engaged in actions like bra burning, like protesting outside of the Miss America pageant, consciousness-raising sessions in hopes of changing the country inside out. And then there was another problem. By the 1970s, conservative movements reemerged to challenge the constitutional and the conservative changes that had been achieved during the prior decade on behalf of both people of color and women. So it turned out that these movements, too, could and did deploy legal rhetoric to advance their causes. And thus we see the promise and the peril of social movements' strategic and opportunistic deployments of law. So I'll conclude with some good news and some bad news. The good news is that non-experts, the people themselves, can be law shapers and law interpreters. They can influence the path of the law. All manner of social movements can and have leveraged law to make legal claims for moral suasion, to identify and critique cultural norms, to mobilize politically. And rights talk can and has been a powerful tool for these social movements. The bad news is non-experts, the people themselves, can be law shapers and law interpreters. Okay? So movements engage in a contest to influence, to persuade, and they're all invoking the same language. To underscore the point, consider that both the pro-slavery and the anti-slavery forces are making moral arguments based on the same language. Or think about something like any issue, constitutional issue. Think about something like affirmative action, where the 14th Amendment, equal protection, can support colorblindness or remedies for discrete and insular minorities. Think about liberty. supporting reproductive choice or its opposite. So all of these movements borrow tactics from one another, and it's a very messy engagement. Nevertheless, in the final analysis, I believe in this interplay of ideas and movements and the role of law in them. And I commend it to you as lawyers, as future legislators and judges and change agents. You are the inheritors of the rewards and the risks of the democratic experiment. Thank you, and I'm happy to take your questions.